Good morning, ladies, and some light would probably be helpful. There we are. Good morning and welcome. I hope and trust you are well. I just want to double check if we have any people with last-minute issues. Let's just double check quickly. Everybody seems to be okay. Perfect. So, ladies and gentlemen, I just forgot. I better share my screen. Otherwise, it's not exactly going to help, is it? There we are. There we are. Oopsie. Now it says I'm screen sharing, but now where has my presentation gone? Hey, boy. Okay, let me just figure myself out here. And then we shall get started. If I can just figure out what is going on. There we are. Okie dokie. So good morning and welcome to the rental sphere. I hope and trust you are well. I just want to find my chat's gone. Where did my chat go? Let's see if I can find it again. Should be here somewhere. There we are. Okie dokie. Good morning, Barry. Good morning, Lizette. Good morning, Lauren. Okay, ladies and gentlemen. So just double checking that you can hear. Well, I'm assuming you can hear me because people did respond with good morning. Let me just make sure that everything is on silent. And that you can see my screen, which is this one that says Rental Sphere Lease Renewal Workshop. Could somebody just confirm with me that you can see that? Good morning, Anita. Thank you, Lauren. Thank you. Okie dokie. So good morning from a chilly Cape Town. I hope and trust everybody is well. Just so that you know, this morning's, for those who are maybe joining late, or, well, actually, if they're joining late, they're not going to hear me, are they? My voice is a bit funny. Don't worry about that. We will get through this. But we are recording. Let me just double check. Yes, we are recording this workshop, and the recording will be available. I know that some of the things we are going to touch on are maybe a bit of a new concept. What we actually did is we've had a lease renewal process and procedure for a long time. And about a year and a half ago, a situation happened with a client in our inner circle that got us to revamp the whole procedure and take a totally different approach, which I'm going to share that story with you and everything with you this morning. Also, Ishmael Mohammed, one of our legal partners at the rental sphere and in the inner circle, will be joining us a little bit later on. So if there are legal technical questions, I might pass those until he joins us, so that he can share his wisdom and his knowledge with us on particular legal matters. Then earlier, I think it was earlier this year, when I was having a chat with Elise Leroux, the CEO of Expello. We were talking about, or she actually asked me about lease renewals and why people don't do revetting, et cetera, et cetera. And we had a discussion, and it turned out that a lot of situations were happening where people weren't able to pay their rent and ended up on Elise's desk, who deals with breach management. And let me just close this so that I'm looking at myself, which is never a good thing. And we reviewed that, and based on Elise's experience, we then went and updated our whole procedure once again. So the process we're going to be going through today, we're going to be covering initially, just so that you know, actually, let's do this. Let's see if we can do this. So what we're going to be doing today, actually, if only I can get, is we're going to be talking about Section 14 of the CPA, which is, of course, our guiding legislation on this particular matter. We're then going to be talking about FICA, because a lot of people aren't fulfilling their FICA requirements with lease renewals. We're going to be talking about best practice guidelines and our best practice renewal process, which we have just updated earlier this year. I think we're on version 6 now, or version 4, I can't remember. We're then going to be talking about, and this is one of the key matters here, is the default position. The default position at the end of a fixed term lease. And like many other people, I, like everybody else, was always of the opinion the default position is conversion into a month-to-month lease, until one of our clients, one of our members in the inner circle, had an issue. And that's where Ishmael came in, and that's why Ishmael will be joining us. And it turned out that for some or other reason, I, as well as many other people, had been misunderstanding this process. And so that's why we've highlighted it, and we've changed our whole approach to lease renewals, or we changed our whole approach to lease renewals about a year and a half ago. We're then going to be talking about the landlord and the tenant communications. You know, one of the matters is in rentals, we have quite a lot of disputes, misunderstandings, differences of opinions, whatever we want to call them. And often it's because we forget how much we know. We work in this industry every single day, and we forget that other people, like our landlords and our tenants, the people that we communicate with, the people who are the bread of the sandwich that we're always in the middle of, the filling of, are not working in this industry all the time. So we need to take some time to explain these things to them. And then we'll be talking about what I suggest as timeframes and deadlines, and documenting the renewal. So let's talk about, there will be a recording, as I mentioned. I'm going to try and get that out to you. I will make it available, I'm hoping this afternoon, on Zoom to you, so you'll get the Zoom recording. It will then be uploaded in the course of the next week to our rental training portal. Inner Circle members will get it in their Inner Circle training library. And you will be seeing as we go through that we have a checklist and a whole set of communication documents. I can't remember how many there are. It's about 30 odd. And we will be sharing those. So Inner Circle members, as part of your membership, you will be getting those for free. That will be part of your membership, or not for free because you are members. And for attendees, the normal price for that pack is $9.99. And if you use that coupon code RW for renewal workshop 2507, RW 2507, you will be getting a 50% discount if you want to purchase that and implement. Now, one of the things I think that makes us different from many other training institutions is that we try and prepare these documents and these packs for you to help you implement. Training is only the first step. The second step of the process is implementation, and implementation is the step that makes the difference. So we really, really try and make it as easy as possible for you. So just to give you an idea of that pack, and I thought I put something somewhere that had all of the information in it, but oh wait, I'm just a little bit confused. Here we are. So that pack that will be available, you will see has got it's version 4. Our checklist, version 4. We have a cheat sheet for the Consumer Protection Act, Section 14. And then we have there's 15 and 13 plus tenant communication templates. So that will all then be included in that pack if you would like to purchase it, to enable you to, oopsie, let me just find my place again, to implement everything immediately. So let's talk about this case study. The situation was actually one of our Inner Circle clients that contacted us. with a situation, and the following was the question. There was a tenant who had a fixed lease until the 31st of July 2023. So end of July. It's actually almost 2 years ago. Well, actually, it probably is 2 years ago now. And prior to the end of the lease, before they started, before they sent out their 40 to 80 business day notice, which we'll talk about soon if you think I'm talking Greek, the tenant requested a 2-month extension to that. And of course, they had to ask the landlord. So we can say that negotiations or discussions started about that extension. When the time came for the 40 to 80 business day letter to go out, they were busy with the negotiations. So understandably, they didn't send out the 40 to 80 business day letter because they were busy trying to extend the lease for 2 months. In the end, what happened was the landlord agreed to an extension and the tenant was informed. On the 9th of July, so the tenant was informed and the tenant said, fantastic. On the 9th of July, we're talking 22 days prior to the end of the fixed term lease. The tenant then emailed the agent and said, listen, yeah, thank you so much for arranging that extension. However, we have decided we're going to move in any case. So this was a 22-day notice. And the question that was then put to me was, Sean, can we charge them? Can we hold them responsible for the rent for August? And the question was, could they or couldn't they? If you believe they could, if you believe the tenant can be held responsible, could be held responsible for that rent for August, please pop 1 in the chat. If you think they couldn't, please pop 2 in the chat. This is the situation. This is the situation that created this whole rethink. And this is where Ishmael came in. And it was one of those situations where I said to Ishmael, I'm assuming blah, blah, blah. And, when Ishmael calls me back and doesn't just send me a WhatsApp, the conversation normally starts off with, Sean, this is not as simple as what we think it is. And then I do remember in that conversation saying to Ishmael, but Ishmael, I don't agree with you, etc., etc. And I think he really wanted to say to me, Sean, I'm the lawyer here, aren't I? But yeah, so that is the background to why we did a whole review on everything. Secondly, why we reviewed our process earlier this year and updated things had to do with the latest market statistics. And when I did my previous round of workshops on this topic, and that happened to be in Gauteng in May, we looked at the TPN stats. And at that point, we only had the stats available from the end of last year. Subsequently, just recently, PayProp made their most recent stats available for the first quarter of this year, which are the most up-to-date stats that I'm aware of. And there's a few things there that I want to point out because I think we also have to look at our processes and adapt our processes depending on the market conditions. So what they called the national highlights, okay, in the PayProp report was the average rents year on year. In other words, last year's rent compared to this year's rent. And we're talking national averages because obviously everybody's in a different province. Rose by 5.2% in January compared to the previous year, 6% in February, and 5.5% in March. And February's growth, that 6%, is a new post-pandemic record and the highest recorded year-on-year increase since August 2017. I beg your pardon. I have my handy ginger tea. So if you have a look, you'll see that the number of tenants in arrears has come down slightly to 17%. The average rent is at an all-time high in the country of 9,132 Rand on average per month. And the rental year-on-year growth is 5.6%, which is the average of those 3 months for the quarter. What does this say to us? Obviously, on a positive side, from a landlord's perspective, this is fantastic news. Rents are going up. But on our side and on the tenant side, this, given the context of the fact that life is becoming more expensive, and I'm talking life in general, you look at inflation and all those things, rents are also becoming a lot more expensive. So if affordability becomes more and more important, and as the industry tasked with helping our landlords minimize their risk, this comes back to us, that it puts a huge responsibility on us to ensure that people, when they are applying for rentals and when they are reapplying, when we are considering renewals, we need to take this into account. So this is the best that South Africa's rental market has performed in a long time. This is all from this PayProp report of Q1. And if you pop onto PayProp, you will be able to find it on their site if you want to download it. Every single province, and this is very unusual because I can't recall this happening recently. All 9 provinces experience positive rental growth. I love the way they put that, positive rental growth. Essentially, tenants are more under pressure financially, even in the context of everything else. Now, managing risk is one of our most important jobs to try and set up the lease. And I just want to pause here because this is the initial lease as well as any renewal. We need to set up that lease for success. And one of the things is the managing risk, which has to do with affordability. Landlords rely on us to place a tenant and to renew a tenant who will pay the rent reliably and leave the property in a good condition. The reality is, and let's accept this, risk can never, never, never be eliminated. We don't know. Life happens, so to speak, but it can be measured and it can be mitigated against. Compared to a year ago, the share of minimum risk tenants has grown slightly, but the share of high risk tenants, and this is what's become important, and that's why we've adapted everything. The share of high risk tenants has increased by 1%, which sounds like a little, okay? 1% over the past year. And the fact that the more applicants are falling into the high-risk category demonstrates the importance of tenant vetting and re-vetting at renewal. If we don't carry out proper checks, the chance of placing, and this is directly out of the PayProp report, is the chance of placing a high-risk tenant is worse than 1 in 4. Based on the most current stats. And coincidentally, while I was finalizing my prep yesterday, in LinkedIn, I came across this PayProp article, which said 1 in 4 rental applicants are deemed high risk. Ladies and gentlemen, that's important. 1 out of 4, 25%. 25% of applicants and people who are already there because it has to do with the economy. So why tenant vetting and specifically re-vetting? Who, maybe I can just ask this question, you don't have to answer. There are people who do a full re-vetting, there are people that do a full reapplication. Do you reconsider the affordability of tenants at the time of renewal? Somebody said to me yesterday when they called me and they couldn't book, and they said to me, Sean, I have to attend this because I've got into trouble before on just renewing as if it's a given. And there are a lot of people that still renew as a given. And so if you are renewing as a given, in other words, it's almost considered a right, or it's almost considered automatic, okay? Then please listen carefully and please reconsider your position based on what we've just looked at. It's becoming more risky. So we're looking at affordability, ensuring financial stability of the tenant. In a 12-month period, remember the last time we looked at these people who have now just, let's say they finished a 12-month lease. I think it's the most common initial lease. The last time we looked at their position was 12 months ago. We don't know. We don't know what has changed in their position most of the time. There are people who do the consistent monitoring or the ongoing monitoring that is provided, that service that's provided by TPN, but there are lots of people that don't. We don't know if they're still in the same position. Think about where you were 12 months ago and think about where you are now. Has your life changed? Have you had a career change? Have you had a job change? Has your salary gone up by the same amount as 5.5% or 5.6% or 6%? Has your income gone up by that amount? Which rentals have gone up? If you had to have applied 12 months ago, think about where you were and what you would have qualified for. Would you qualify for the same at the moment? And the reality is, most of us, many people, have technically gone backwards because we're looking at inflation, which I think is something like 5.2% or something. And then you've got rental going up even more than that. So we've got to reduce the chances of arrears and potential evictions. And this is where, this discussion with Elise came in, and protect the landlord's investments. So a few of the things that we've built in that I think is very important for us to reconsider here is, what do we do with tenants in breach? One of the discussions that Elise had with me, and Elise will be joining us, she's busy on another webinar, but she will be joining us after 11 as well. Tenants in breach. What happens with tenants in breach? I often get queries from people who are saying to me, Sean, we've got this tenant, they were there, we renewed and blah, 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 and now we've got a problem. And then it turns out that the tenants were in breach because people think that only the landlord has a say on renewal. Ladies and gentlemen, we often forget how important our input is and how important it is for us to be honest with the landlord and to say to the landlord, when a tenant is in breach, if somebody is already in breach of their lease obligations, why on earth would we want to continue in a fixed term lease with them? Because surely if you've been getting a certain behavior, why are we now expecting that behavior to change? And then people will say, but Sean, they promised they were going to do this or whatever. Unfortunately, we all know what happens in those situations. So at renewals and revetting, I believe revetting has to be at least a step in your renewal process. Some people do a whole full reapplication. Who does a whole full reapplication? If you do, just pop one in the chat. And then, ladies and gentlemen, you'll see who does. There are people who do a whole full reapplication. And I think that may actually be the absolute best practice. I can't admit to having done that. So we want to see who is in breach. We need to deal with tenants in breach. Anita does a full application. Lorraine does a full reapplication. You see, it has to. So there are people out there doing it. So tenants in breach, we've got to look at. We've got to recheck affordability. A lot happens in 12 months. We've got to get updated credit checks. A lot happens in 12 months. And then top-up deposits. Please never, ever, ever skip the top-up deposit. Never, ever skip the top-up deposit. Corinne just said, I had bad tenants and gave them notice to move out on lease expiry. My client only went and renewed for 3 months because as he felt sorry for their dogs. Now he regrets it and said he should have listened to me. Exactly. We've got to. We've got to. Lauren says credit check and affordability. Yes, top up deposit. I'm going to give you a solution for when, and I'm going to, in my process I've worked in, because I know that landlords will often worry about, it's actually quite interesting. Landlords worry about having a vacant property, but they don't realize that a vacant property has a solution of refilling, re-tenanting, whereas a property tenanted in a fixed term lease is a much bigger problem, because you have to go through a legal process and live your way through that. So let's go now quickly, ladies and gentlemen, into the Consumer Protection Act, Section 14. So firstly, let's talk about the Consumer Protection Act. Section 14 deals with the renewal of fixed term agreements. The Consumer Protection Act, when we're looking at a lease agreement, we have a provider, I think it's called a provider, they call it a service provider. The landlord is the provider. The important thing here is that the tenant is the consumer. So when we're looking at a lease agreement, remember we are actually talking, in our language, this is called the Tenant Protection Act. The Tenant Protection Act. So now, firstly, it protects tenants. Remember that when we're looking at a lease agreement, it is the Tenant Protection Act. Always remember that the tenant is the protected party here. Now, the Consumer Protection Act does not apply to every single agreement. It protects tenants or consumers that are natural people and that are small businesses. Okay, small juristic entities. That's the first important point here. And the law defines small as an asset value or an annual turnover of less than 2 million rand. So Jack and Jill's Garden Services, but Old Mutual is not protected. Okay, so that's the first thing here. But now when we narrow down to Section 14, Section 14 has a smaller group. Any lease that is between a company and a company, or a juristic entity and a juristic entity, is excluded from this. So essentially, yeah, we are dealing with a subset of the people. Somebody has, thank you. Can you all just make sure that you are muted, please?
Shit. Sorry.
So the important thing here, and I do have a checklist. Let me just find my checklist quickly. And that is included in our pack. And here's my cheat sheet. Let me just get my cheat sheet. So basically, what I've done is I've created a cheat sheet for you. This is in that pack, by the way. So if you're looking at a lease agreement, your landlord can be a natural person or a juristic entity. The size of the landlord is irrespective here. The Consumer Protection Act protects natural person tenants and juristic entity tenants, but only small juristic entities. That's the first important point. Okay, I just want to show you what's in the checklist. Oopsie. Now, if we look at Section 14, natural person landlord to natural person tenant, it falls under the section. So everything we're going to talk about today falls under that. They fall under that. A natural person landlord and a small juristic entity falls under this. A juristic entity landlord and a natural person tenant falls under this. But if the landlord and the tenant are both juristic entities, that is excluded. So that's the most important part here. That's the most important part here. So, firstly, we are now going to focus on the Consumer Protection Act, Section 14. So if you've got a natural person tenant and a natural person landlord, definitely. And Section 14 says, and we're going to pull this apart, if a consumer agreement is for a fixed term, so we are only talking about fixed term agreements, which is quite simple. I mean, that's sort of quite logical, because we're talking about renewals, and you only renew something probably if it's in a fixed term agreement. But this puts certain obligations on the landlord. And it says here in section 40, not more than 80 days, 4 months, not more than 4 months. This is 80 days. Who on earth is trying to, sorry about that. People. I don't know why people think they can call me. Now I've lost my place. Let me find myself again. Okay, I'm just going to have to go out of here. I apologize. Let me actually just switch my, there we are. Apologies. I actually switched it off, but then I must have opened it again. There we are. Not more than 80 days or less than 40 business days, my apologies. Not more than 80, nor less than 40, so between 2 and 4 months before the end of the fixed term agreement. Between 2 and 4 months before the end of the fixed term agreement, the supplier, who's the supplier here? The supplier of the property here is the landlord. The supplier or the landlord must notify the consumer, the tenant, in writing or any other recordable form of the impending expiry date. So, ladies and gentlemen, this is one step that is often missed out because people think that there's this automatic conversion to a month to month. So if we don't do this, it will convert. I'm going to show you that that isn't the case, and you can end up in a lot of problems. So the Consumer Protection Act says very clearly that between 4 and 2 months prior to the end of the lease, the landlord is obliged to contact the tenant. Now, where it says the supplier, which means the landlord, we also need to read something else in here. It will be, according to the Rental Housing Act, landlord's definition is the property owner and or their duly authorized agent. So if you are duly authorized agent, if you are mandated to deal with this for the landlord, then you can also read this as not more than 80 nor less than 40 business days before the expiry of the fixed term of the consumer agreement or the lease agreement, the agent, if you are mandated to do this, must notify the consumer or the tenant in writing of the impending expiry date. You will see there are no exceptions here. Please never, ever skip this step. Too often when people contact me with problems, they have a problem because they have skipped this step. And the only time is unless the consumer expressly directs this. The only time you can skip this is if this consumer expressly has asked for us to terminate the agreement or they have already agreed to a renewal of the fixed term. Other than that, please never, ever, ever skip this step. Just by the by here quickly, another point here, and that's something that I've come across recently where I've seen people have made a few faux pas here. And there is a maximum duration for fixed term agreements, which is 24 months. So please bear that in mind whether you're doing an initial agreement or whether you are doing a renewal. We've already covered that cheat sheet. So the important thing is that unless the consumer, actually, let's just go back to that point. Unless the consumer has directed you to terminate the agreement prior to you sending this out, directed you to terminate the agreement. In other words, the tenant has given notice and said we won't be renewing. Okay? Or has agreed to a renewal. This 40 to 80 business day letter needs to go out. If you skip that step, you are left without many, many defenses because you haven't told them what's going to happen. Now, ladies and gentlemen, let's talk about FICA. I know it's a bit of a swear word. I know it's a nightmare. I know it's all of those things. What does FICA have to do? What does FICA have to do with What does FICA have to do with lease renewals? Well, it's quite simple. The Financial Intelligence Center Act says, prior to entering into a business relationship with a client, you have to FICA your client as per your risk management and compliance program. So I can't tell you exactly what your steps are because that's unique to your organization. But I can tell you generically, you have to identify them. You have to collect certain documentation. Identity and proof of residence are two pieces of those documentation that you have to collect. Okay? But you don't just collect it anymore. About 3 years ago, that changed. You actually have to verify it. You then have to go an extra step and do a risk analysis on the potential client. You have to check them against the terrorist financing and sanctions list. You have to do an adverse media check against them. So there's all those things that have to be done. Ladies and gentlemen, importantly, when you renew the business relationship, you have to rinse and repeat all of those matters. So it's important that you have a step for refeaturing, if that is the word, refeaturing at lease renewal. Refeaturing at lease renewal. You have to make sure that you have confirmed the identity and you have to confirm the identity and you have to, well, you know their proof of residence properly, but you have to check them against the TFS list again, the terrorist financing and sanctions list, and you have to do redo an adverse media check and anything else that your risk management and compliance program says. The risk management and compliance program, the details of those steps are set out in your risk management and compliance program for your organization. Now, when does the lease automatically, in inverted commas, or one can even say, does the lease automatically convert to a month-to-month lease? When or does it? Let's go back to Consumer Protection Act Section 14, which says, on the expiry of the fixed term of the consumer agreement, on the expiry of the lease agreement, it will automatically be continued on a month-to-month basis, subject to any material changes of which the supplier has been given notice. This is the key point here. Only the expiry. Okay, so let's take an example. Let's take that example that I looked at earlier, where the lease was coming to an end on the 31st of July, 2023. When does that lease expire? When it says on the expiry, it will automatically be continued. This is where lots of people think, oh no, but if I don't send the 40 to 80 business day letter, then it's okay because it's just going to convert to a month-to-month lease. It will only convert. Think about this. The expiry of the... Lauren, thank you, Lauren. Lauren's just written there, midnight on the 31st of July. Ladies and gentlemen, this seems so trite, but it has massive implications. Massive implications. And this is exactly where things fell apart with that example that I gave you, where I was totally wrong with my example, with my answer, because it only converts to a month-to-month agreement on midnight on the 31st of July, midnight on between the last day of the lease and the day after the lease. The default position of a fixed term lease, and this is so important. You know, when I say it, sometimes I think it sounds so simplistic, but there's a lot of mistakes being made with this. Let's say we have a fixed term lease which ends on the 31st of July of this month. 31st of July 2025 for those who are watching the recording. The default position of that lease is it ends. It ends on the 31st of July. If nothing is done to extend it, it will end. It will end. If those tenants are in the property with the landlord's permission after that, it will then convert to a month-to-month lease. But if they're not in the permission in the property with the landlord's permission, they are then illegal occupants. And this is so important. This is so important. Don't worry if it sounds a bit of a mind twist. We are going to go through this in more detail when we get into our particulars. So on the expiry, it will automatically be continued unless the consumer expressly directs the supplier to terminate or agrees to a renewal for a further period. But the thing there, I think that I don't know why they wrote that into the act, because that causes a lot of confusion. Let's go back to our case study. The fixed term was ending on the 31st of July 2023. The tenant asked prior to them sending out the 40 to 80 business day notice for a 2-month extension. There were some negotiations. They'd started asking, but the landlord wasn't getting back to them. So because of that, they didn't send out the 40 to 80 business day notice. Okay, they didn't send out the 40 to 80 business day notice. So there was no clarity as to what was going to happen. And we'll look at a 40 to 80 business day notice just now. The 40 to 80 business day notice is the letter, let's remind ourselves here, that says to the tenant, your lease is ending on the 31st of July 2023. The landlord is offering you the following options, if the landlord wants to offer options. So if that is not sent out, there is no clarity as to what the options are. The landlord then, in the course, in the course of this process, said, yes, no, that's fine, we can extend for 2 months. The tenant was notified by WhatsApp, which is in writing, on the 8th or I think it was the 9th, I don't know why I've got a typo. The tenant said, fantastic. No? Then, on the 9th of July, maybe they were notified then, they came back on the 8th, okay? The tenant said, actually, we've decided we are going to leave in any case. And the question here became, can they be held responsible for August rent? Now, I'll tell you what my argument was, because I got it wrong. And I'm happy to admit I got it wrong, okay? Because that's how we learn. I said, of course they can be held responsible for the August rent. And the person who contacted me, who's very knowledgeable, said to me, why? And I said, because it's a month-to-month lease. It was now going on to a month-to-month lease. Remember, though, we were here at the time. No? We were around here at the time. So we were here. Let me leave that cursor there. And they said to me, Sean, when does the month-to-month lease start? And I said, oh, probably over here, because the month-to-month lease actually starts on the 1st of August. But, of course, you can give a calendar month's notice with a month-to-month lease. So actually, yeah, we can still get, they should have given the notice here. This is when I contacted Ishmael, who will be joining us in an hour or so. And Ishmael called me back and said, Sean, this has got a lot more to it. Because, ladies and gentlemen, when we were here, we were in a fixed term lease. The fixed term lease, the original fixed term lease ran up until this date, the 31st of August, 31st of July. The fixed term lease ran up until here. It was a fixed term lease, and a fixed term lease says very clearly, It starts on the start date and it ends on the end date. And this fixed term lease said it was going to end on the 31st of July. It was going to end on the 31st of July. Remember, no 40 to 80 business day notice letter had been sent out. In other words, the tenants had not been notified of any options after this in writing formally as is required under the Consumer Protection Act. This lease was a fixed term lease. It would only have converted to a month-to-month lease at midnight on the 31st of July if the tenants had of stayed in the property with the landlord's consent. So over here, it had not yet converted. That's why I tend to hate this conversion these days after this. It had not yet converted. So this lease was ending. And I know I'm emphasizing this because this is the key to this. So when they said we're going to leave, ladies and gentlemen, they weren't actually giving notice. They were just keeping to the terms of their current agreement. The only commitment the parties had made to one another was that they could stay there and they would pay rent and whatever their other obligations were up until the 31st of July. They made no further obligations after that. And so the landlord could not hold the tenants responsible for August because they had not even done a 40 to 80 business day notice. They had not entered into any other extension, nothing. So the tenants could legally leave on the 31st of August. The notice actually has nothing to do with anything. The lease was actually only, the 31st of July. The lease was only until the 31st of July. The lease was only until the 31st of July. So the end result was that I think in this particular case, the agents, because they didn't understand this and because the landlord was now obviously unhappy and out of pocket, I believe that they compensated the landlord because of this slip up. And this is, I must admit, I've been in this business for 20 odd years. This is the first time this situation has happened. This is the first time if this situation has happened. Sonia says it would only go on to month if that was negotiable. Yes. Yes, Sonia. If a 40 to 80 business day notice letter had been sent out, so Sonia says it would only go on to month if that was negotiated. If it was an extension of only 1 month, it would not have been seen as a month but an extension. Ishmael assisted us in a case like this now as well. Exactly. Whatever is going to happen after this date, ladies and gentlemen, please, I know this sounds anally retentive, but you all know I am, because I'm trying to help you protect yourself and your landlord. If there is going to be any extension here, any extension, please make sure it is documented. That is the only way, the only way. Okay, the only way. Lorraine says, but the tenant also has to give his notice prior to the ending of the lease. Goes both ways. Lorraine, unfortunately, and when Ishmael joins us, this is one thing, and I'll try. Please remember your point where Ishmael joins us, because the tenant does not have to give notice, Lorraine. And thank you for asking this question. I'm not picking on you. Please, please, please don't misunderstand this. Remember the original lease. The lease was a fixed term lease. Nobody has to give notice. The landlord has to do a 40 to 80 business day letter under the Consumer Protection Act, telling the tenant. Actually, let's go there. Let me just go there quickly. On the expiry of the fixed term, not more than 80, nor less than 40 days before the expiry of the fixed. Remember, this is a fixed term agreement. Nobody has to give notice, ladies and gentlemen, and this is the important point. The lease has only been entered into for a fixed period with a start date and an end date. That's the only obligation between the two. And this is where it's so easy. It's so easy to get confused. The lease does not have to be terminated. It will automate. The default position is that it will terminate. That is the crux to this whole thing. The lease was entered into. Let's say there's a lease that ends on the 31st of July of this month. The 31st of July, 2025. It was entered into on the 1st of August last year. The agreement gives the tenant the rights to stay there until the end of this month, and they have the obligation to pay rent. The landlord is obliged to let the tenant stay there until the end of this month. Okay? And will collect rent. Nobody has the agreement the agreement says in it, there's a start date and an end date. I know this, when it clicks, it almost becomes simplistic. And I'm hammering on at this because this is a very key thing here. The lease agreement has an end date. Any contract that has an end date ends unless it is extended. And that's exactly why it is so important that you must, without fail, do your 40 to 80 business day letter. Because your 40 to 80 business day letter notifies everybody. Everybody's got in their mind that, no, this will convert. A tenant, if they have not signed, we can confirm this with Ishmael when he joins us. If they have not signed anything and no agreement has been reached for what will happen after midnight on the 31st of July, ladies and gentlemen, the tenant can leave at 6 p.m. on the 31st of July and not be held liable because the lease ends. Because the lease ends. So the important thing here is the lease ends on the termination date unless an agreement for some form of extension has been entered into. And a verbal agreement, ladies and gentlemen, does not work. Because your lease, just about all lease agreements that I'm aware of say, the entirety of the agreement between the parties is included in these written pages. And nothing else, unless it is reduced to writing and signed by both parties, will be binding. So, unless an agreement to the contrary is signed, or the tenant stays in occupation with the landlord's permission. But that is a dicey one, because if that tenant decides on the 25th of the month, they find something and they move out, you will be hard-pressed to be able to force them. You may be able to get away with it because you've got some other clause in your lease agreement, but all of the lawyers that I have spoken to, and they're all expert rental attorneys, have said to me, Sean, we are not comfortable going to a tribunal or going to a court on this matter because we're not assured of winning because we think we're on very thin ice. Lauren says, I send terms at 60 days and give the tenant a date to serve notice by 1 week to try to negate. Exactly, Lauren. That's why we'll go through our process in our second half. It's incredibly important that we send out the 40 to 80 business day notice because what does it say? And look, I'm not saying I'm perfect. I've done this. I was just lucky it never happened to me. Okay? The 40 to 80 business day notice says, Mr. and Mrs. tenant, or Mr. and Mr. or Mrs. or Mrs. whatever tenants, your lease ends. And remember, we send this 40 to 80 business days beforehand. So we've got enough time to document this. So between 2 and 4 months, we suggest 3 months because it's like at the middle point. Mr. and Mrs. tenant, your lease ends on the 31st of July. Your lease ends. ends on the 31st of July. The landlord is willing to offer you the following extensions. We need confirmation in writing. Please tell us which one. That is what it does. Sherilyn has asked me, can we send out the 40 to 80 days notice on WhatsApp? I personally believe that is not best practice or professional. I also have another concern about WhatsApp. But we'll ask Ishmael that. Sharon, thanks for that question. I'm always cautious of WhatsApp, and I'll tell you why. People don't back up their WhatsApp. People don't keep copies of it, all those sorts of things. It's much better to by the way, you also have to do it in terms, sorry, Sherilyn, just to interrupt there. The notice, any formal notice, and a 40 to 80 business day notice is a formal notice. Any formal notice in terms of the lease, any notices in terms of the lease have to be sent out in the way that your lease permits it to be done, or your lease stipulates. Please also look at your leases. You know, lots of people don't update their lease agreements, and they're sending out emails and all these things, but they haven't updated their lease agreements for years, and the lease doesn't actually make provision for email notices. So make sure that you send it out in whatever way your lease says it needs to be sent out. And ladies and gentlemen, what was I going to say there? The way your lease sends it needs to be sent out. I think that's what I want. But we will ask Ishmael that. So let's look at our best practice guidelines. Lease renewals must be carried out in accordance with the requirements of the Consumer Protection Act. That's, of course, if the Consumer Protection Act applies, and Section 14 specifically applies. Okay? Lease renewals must be carried out in accordance with the requirements of the Consumer Protection Act and the FICA legislation. The landlord, ladies and gentlemen, remember, what does the Consumer Protection Act say? 40 to 80 days prior to the expiry date of the lease, the landlord must notify the tenant. It's not the tenant's job. It is the landlord's job. The agent cannot charge for this. This is part of lease management, something else I've learned from Ishmael, for this particular step, because this has to happen before the end of the lease. You already have a management contract for that lease, and this is one of your obligations in terms of your mandate, potentially. If it's not in your mandate, by the way, you need to have a look at your mandate, because you need to have permission to be able to do this. So the landlord's instructions must be sought first, because the landlord decides what options. Always make sure to get your instructions in writing, ladies. This is just a general, CYA, cover your behind situation. I believe that we should be providing a landlord with a current market rental valuation if they want to renew. If they want to renew, and there's various ways you can do that. You can look at what else is on the market, because especially look at the current situation. Landlords are now reading highest rental in years. Actually, probably in forever, to what, 5,190 Rand or whatever it is a month, or no, 9,100 something Rand per month. And landlords are thinking, I can increase it. But that might be what the market out there says you can do statistically. But can your tenant afford it? Can your tenant afford an increase that is in line with market rates? Do you want to retain this tenant? Are you going to adapt? There's all of these things that come into this renewal process. So the landlord also then needs to know what else is happening in the market. Because a lot of people looking. If we look at Cape Town, for example, at the moment, rents are high. So Cape Town is hard because people are under a lot of pressure. I'm just giving you an example. Please never, ever, ever send out the 40 to 8, skip. Never skip the 40 to 80 business day notice. Never, ever skip the 40 to 80 business day notice. Never accept any verbal instructions from tenants. Those things like, Oh, yes, no, we're going to extend. Yes, no, we're going to stay. And then you think, okie dokie, well, on the 31st at midnight, it's going to convert to a month to month. But then they wake up. They lose their job on the 20th. They get a notice on the 20th of July. And they decide they're going to leave and, I don't know, go live in a tiny house or something. Ladies and gentlemen, your landlord's going to think that you don't know what you're doing. And that's what we're here to protect you against. Ensure that instructions are in writing from everybody, because the only agreements that people can be held to once a written lease has been entered into, any changes to that, any extensions to that, any amendments to that can only be enforced if they are in writing and signed by, normally I'll say both parties, all parties. By all parties, I mean if there's two signatories to the lease on the tenant side and two signatories to the lease on the landlord side, everybody has to sign those. Everybody has to sign those. But please remember, a fixed term lease, we talk about these things so glibly. A fixed term lease, a fixed term lease. But then we treat it as a month to month because it's just going to convert. It only converts at midnight. Please, you don't want to wake up with this problem. You don't want to wake up to this problem. So let's have a look at the pack that and we're going to go through the practical side here, and we've helped you by pre-writing a lot of stuff for you. You're welcome to change it because if you purchase the pack or if you're in the inner circle and you get the pack as part of your member benefits, you will get the editable version. So this was updated in May, just before I went to Gauteng. We've got the checklist, which we'll go through. We've got the cheat sheet, which you've seen. Oopsie. We've then got a number of landlord communication templates. Rental appraisal, instructions regarding the end of the fixed term lease, because we start off with the landlord, the follow-up with the landlord's preferred options, the lease renewal, a whole lot of documentation there. There's a whole lot of tenant communication templates, telling them, you're sending them, reminding them, all of those things, reminding them that their lease is going to end. One of the things that people say to me is, but Sean, they never get back to me. Ladies and gentlemen, we can't sit back passively because we're getting paid to do this job. And as professionals, we can't sit back passively and say they won't get back to me. We've got to figure out a strategy to make them get back to us. And one of the strategies that I've figured out works, okay, and especially after learning what we learned 2 years ago, when we made our initial changes to close that gap, so to speak, that loophole in the legislation, which has probably never been there. We've just never really experienced it. But it brings it home to you when one of your clients has to pay us a lot of money, because a month's rent is a lot of money. Is that by the tenants knowing that if they don't do something, their lease will be ending, is a huge motivation for action. So that is the whole approach. And in hindsight, it's an approach that we should have taken a long time ago. But I didn't even think of it because I never had the problem. And that's one of the advantages of, this sort of training, this sort of situation where we share things with people. The checklist, and this is the full checklist. You'll see, I know it's a bit small, but don't worry, we'll go through it just now. The landlord's instructions must be sought before the 40 to 80 business day letter can be sent. All instructions from the landlord and the tenant or agreements must be in writing. If a no lease renewal is concluded, the lease will end. That's the position you have to take because it is the only position that is correct. The lease will end on the end date. And then we talk about does section 14 of the CPA apply? Are the tenants in arrears or breach? We're going to get into that after the break. Diarise and follow up daily to get landlord's instructions. What happens if the landlord says to you, but I don't, you say to them, but listen here, this person is in 10,000 rands arrears, or this person is in breach of their lease agreement. We cannot continue in a fixed term lease. What happens if the landlord says, but I'm too scared to have an empty property? Going to give you a way to deal with that. We've got a letter there. And always, always, always make any extension conditional on you doing certain checks. Always, always, always do that. So here's the bigger text. And you are going to get an opportunity to purchase this. So the landlord's instructions must be sought before the 40 to 80 business day letter can be sent. We're going to go through this in a lot more detail, don't worry. All sorry, this is the bigger writing. We've got to be able to check. Okay, let's go back to that quickly. So, best practice guidelines. Lease renewals must be carried out if the CPA Section 14 applies in line with that, because that's the only way we can do our jobs properly. I suggest to you, remember now the Consumer Protection Act says 40 to 80 business days, which means 4 to 2 months prior to. I always used to have a company policy whereby we initiated 90 days before the end of the fixed term lease. In other words, more or less 3 months. The team needed to finalize those lease renewals before the end of that month. In other words, before 2 months before the end. Okay? Let me just finish. I'll get you now, Elsabe. By the way, I do love the way, Elsabe, that you spell your name. I've never said that, but I always look and I think that's really cool. Any offer of the 40 to 80 business day notice must be subject. Really, I suggest this. Subject to obtaining updated employment and financial documentation and the required screening checks. Please make sure that all instructions and all responses from the landlord and the tenant are in writing so you can hold them to it. It's the only way you can hold them to it. Talk is cheap. Talk is cheap. If no lease renewal is concluded, you've got to stick to your guns that the lease will end because contractually it does. Never agree to verbally to anything else. So let's have a look here. Actually, you know what we're going to do? I'll answer your question now, Elsabe, and then we'll take a break for 10 minutes or so. What is the difference between this pack and the TPN? TPN doesn't have anything like this, Elsabe. This is a step-by-step. Anybody in the inner circle would like to respond to Elsabe, you're quite welcome to. This is a step-by-step checklist for your lease renewal process. We do not include this is not a lease agreement, this is not an application form, this is nothing. This is a set of process documents, standard operating procedures, checklists, communication templates, whatever you want to call it, that goes together with this. So just before we take a break, let me just go. Lawrence just said TPN only does leases, sales packs, etc., not SOPs. Before we go on, let me just figure out how I'm going to do this because I think I did. Well, I thought I did. Somehow I have. Oh, here it is. Here is the, if you go, I'll give you the link. If you go to this link over here, you'll see that the entire pack is available there as a download. If you just go add to cart, because you are getting a 50% discount for attending today. Those of you in the inner circle, don't worry, I'll send that out to you separately because that's part, and it's called Renewal Workshop 2507. Oopsie. If you use that link, then you apply that coupon, you will, oh, sorry, I've got two there. You will see it's going to give, okay. Let me just reduce that quickly, remove that, sorry about that. I made a mistake. but you'll only be purchasing one because obviously it's an electronic format. So you just essentially put that coupon code in there, RW2507, and you apply it, and then you will get your 50% discount because you already paid for the course. So we don't recharge you for the training. Here we are. So it's $499.50. Let me just go back so that you can see the link. I have an idea you can, I think that the short link, oops, the short link is just /rentalsphere.coza/RP6. I'll give it to you again at the end. I'll leave that on there for you, ladies and gentlemen. I think we're going to just take a 9-minute break. A 9-minute break, and we'll start again at 10:20. And from there, we will then move forward. So I shall see you shortly.